Good morning, everybody, and welcome to the Wednesday morning online seminar with Fletcher Day. Today we are joined by Mohammed Haque, who is a consultant barrister, adjudicator and quantum expert, and he's going to be talking about design negligence and your duty to warn. So, as always, if you'd like to ask Mo a question, please use the chat or Q&A facility in the bottom toolbar, and we will put these questions to Mo at the end of his presentation. If there's something that you'd like to ask him but don't wish to do so in an open forum, don't forget you can always email him directly and he'll be happy to answer those questions for you. His email address is currently there on screen, mohammed.haque at fletcherday.co.uk. Okay, without any further ado, Mohammed, over to you.
Thanks, Julie, and good morning to you all who've just joined with me for this brief an hour-long presentation. We're still with COVID, so no face-to-face breakfast seminars, but we hope that we're going to come out of this soon. But till then, we'll continue online. It's sometimes advantageous for those who are traveling like I do. I leave an hour's distance from London, so it's easier for me. But having said that, I would have preferred presenting it face to face so that we interact more. But nevertheless, if you do have a question, as Julie said, please throw it at me either now or later on, and I'll try my best to answer it, because sometimes within this short period of time, you don't actually have the opportunity or ability to explain everything you want to. Now, this is, of course, about construction contracts, and otherwise, well, I don't know about other forms which say talks about design. Obviously, there are other things where the design is a factor, but our discussion is going to be in the context of construction contracts and the construction contracts in England, more popularly used. In other words, I'll be using the model forms of JCT and NEC, and I would also refer to the residual kind of common law fallback position, occasionally also to statutory implied terms, to try to understand the extent and the scope of design liability. Now, who's liable? That's the first thing. Or in other words, who is responsible for design? Because it's common sense that whoever is responsible for the design under the contract, unless they have through an express clause shifted the responsibility or the liability if anything goes wrong to someone else. But the rule is that if you're responsible for the design, you are going to be liable for it if it goes wrong. You know, it's simple logic, and all the model forms and common law are based on that principle. But as we'll see in detail today, that there are different groups of people who might or might not be responsible. Now, essentially, a construction contract is a contract between, in most likely cases, I'm saying, between an employer and the contractor, where the employer wants a project to be built, or a scheme to be built, or a building to be built, and the contractor builds that. However, the employer really, or almost no time, actually designs the scheme of the project, the building. They go to professionals like architects. The architect's name comes first, but I will see that architect is not the only person to whom the employer goes, or to whom the architect goes for detailed designing. And then, traditionally speaking, then it's handed over to the contractor to build. So in other words, in a traditional construction contract, the architect and his professional team designs their project, and the contractor is supposed to build it. So there isn't a question of contractor's design responsibility. It's either the professional team and the employer. And obviously the contracts normally, again, from a standard traditional perspective, the design contracts are with a group of professionals employed by the employer. So the contractor, although is taking the advantage of the design when building the scheme, he doesn't have a direct contractual relationship with the architect or any other person. So from a very narrow contract perspective, the employer is responsible for the design. So if anything goes wrong, if he suffers, it's his headache, you know. And then of course he can make the professional team liable. Obviously architect is one of them. And then it's not the architect alone who designs the project. It's from the architect to the structural engineers, to the service engineers, to the specific design providers like the electrical and mechanical, subsurface, roof and whatnot, you know, from the bottom to the top. There are so many different types of, you know, and the design in UK, the design is defined by RIBA, the Royal Institute of British Architects, in a staged form from stage 0, and it proceeds. Now, design doesn't start till the second stage. So if the brief of the concept of the project is wrong, then that's not a design, okay? However, we'll see later on that a professional may still be responsible if he or she fails to point out a particular aspect which is not achievable or which needed to be incorporated. So that's the type of thing we call duty to warn. So that's one aspect. I've already stated that the architect or the design team, I'm just for the sake of convenience, we will name or use the word architect, but by the word architect, I'm actually referring to the whole of the design team. Now, that's in the simplest model, and I haven't included, of course, the funders and the ones who are providing the insurance, collateral warranties, that sort of people into that game, because they're also interested and they want to ensure that the best party is best party remains, or multiple party remain responsible, because then they have a choice, you know. Now, as I said, I'll be using the word architect for all the design team. And the first question is, is he liable to the contractor or the subcontractor? Now, what for? I mean, he's been appointed, in a normal scenario, he's been appointed by the employer, and he's contractually bound with the employer. And then, you know, why would why would he be required to even be responsible to the contractor, the subcontractor? Whatever the reason be, contractually they are not party to each other. There isn't any privy for each other, and of course, the contractor cannot enforce something written into the contract between the professionals and the employer. So contractually, no. But of course, there is a thing called tort, and if you're not a student of law, I would just mention that the basic proposition is for tort law for this particular discussion, and we'll be considering tort of negligence. You don't necessarily have to be a party to any or be in a contractual relationship to enforce a primary or right or an obligation which someone is in breach against that person who is in breach. You don't need to be in any contractual relationship. So if and so long the the victim who suffered something due to the breach of the person who was under a duty, which is again called duty to warn, under the tort of negligence, and the person who's the victim of the wrong, regardless of whether you have a contractual relationship or not, that person may come against you. So that's what should also be kept into mind. Now, also we have to keep in our mind that more frequently than not, either the contracts in the modern time are design and build, I'll go to that in later slides, or the contractor may have a design portion, and the same sort of rules apply. We will see that the contractors, in any case, impliedly liable for, even if not been stated expressly, a common law for fit for the purpose and statutorily as well. Now, the next thing that comes into mind is the basic principle I have just discussed. It's just kind of a recap that the first thing to remember that the position is the professional is responsible to the employer through a contract, written or unwritten, and then the employer is bound to provide in the traditional contract all the designs to the contractor. And if there is any failure, then if the contractor builds something which is defective in some sort, some type, he won't be responsible as such, because it was not his responsibility. You asked me to build it in a particular way, I did. Now, well, that's the basic position, but of course, the model forms brings in tools which makes it more confusing sometimes, but we got to find out and ascertain, and sometimes even to act in the best interest of the client, the employer's lawyers, and the professional team also try to shift the responsibility, even though the design responsibility lies with the employer. They, through express clauses of the contract, they shifted the outcome and the mistakes. They shifted to the contractor by saying that you are a reasonably experienced contractor, you have to follow the best practice, this, that, the other. So if they fail to. The second thing to cover their own back, the employers employ, or the technique the employers employ, is of course notification of discrepancies. It's always the duty of the contractor, and it's common for the model forms to include a clause expressly that the contractor is liable to check the design and its different components, and if that's there is a discrepancy that the contractor finds, he's under an obligation to point it out to the design team or the architect or whatever way you call it, or the employer, in other words, to the contract, through the contract administrator, of course. And then that will be considered by the architect, and an instruction will be issued, and that will be treated as kind of a change or a variation anyway. Now, regardless of what the contract says expressly, the common law has two sets of implied terms. One is, of course, to take reasonable duty of care, and the other is fitness for purposes. And unfortunately, we will see that the contractor is in a disadvantaged position than normally than at common law. Of course, in the model contract or in the contracts where model contracts have been um, amended to suit the particular situation, that's different. But a common law, the professional team is only responsible for the duty to take reasonable care and show their skills. And also there is a, as I said, also there's a second type of duty under common law implied term in construction contracts that is fit for the purpose. And that's nowadays if the issue is an issue of a failure of material, that comes as well under the statute of Goods and Services Act of 1982. So that's the contractor's portion. The thing has to be the goods they're supplying under the Goods and Services Act has to be fit for the purposes. And there are case laws. The higher courts have already decided that this act applies to construction contract in England and Wales. So contractor has a secondary duty, a common law, as well as in statutes to remember that whatever they do, that has to be fit for the purpose, regardless of there's a mistake in the design. And if he becomes responsible and he doesn't have, as I said, you start understanding the complexity, and he doesn't have a contractual relationship normally with the professional team or architect, then he doesn't have any other option but to sue the architect in tort. And there, the tortious duty to warn comes. And what is a tort of negligence in this context? Well, for the professional team doing something which a reasonably competent professional of his or her standing wouldn't have done, and not doing something which such a reasonably competent professional would have done. So that's kind of more or less Bolam test, or whatever we call it, is the current day law. And it's not a reasonable person would have done, reasonably competent person of similar standing would have done, or a similar professional would have done. So that's more or less the three things you got to keep in your mind whenever the design issue of the responsibility comes into picture. The core situation is, it is in a traditional contract. Of course, exceptions are there, and we will go into that later on. In a traditional contract, it is the employers and their professional teams, again, between them. And the contractor is just to build it as per the instructions of the professional team given to them after and before the contract has been executed or been made part of contract documents. And he shouldn't be, but having said that, contractors frequently have design responsibility under the express clauses. They also have a duty to notify the discrepancies to the employer and the professional team through the contract administrator, whatever name, but project manager or supervisor, whatever name it's called in the particular contract. And then they have the common law duties under the implied terms of contract and the tort of negligence. And that's the duty to warn. So that's that. We go to specific issues. Now, we've already discussed somewhat that the reasonable care and skill. I mean, this more or less comes in many standard forms as well. That, for example, JCT, it says the contractor has to perform with due care and diligence. So it's kind of an attempt to phrase the common law duty of reasonable care and skill, and it's implied in your contract that whoever is designing, whoever is providing a service, be it the professional or the contractor, they are obviously responsible for reasonable, to perform it with reasonable care and skill. And obviously, this particular legal responsibility or the obligation has its root in the historical law of tort of negligence. And tort of negligence, when it has got primarily three requirements. One is that the person who's doing it, he must be shown to have a duty to care for the person who suffered some loss, and then there must be a breach of it, and then the damages that has been caused must be foreseeable damage. So these are the three primary requirements of the tort of negligence. And this first part of reasonable care and skill comes under the duty to take care. And obviously, we will see again later on in the slide that it doesn't extend to everybody, anybody and everybody. And of course, there is this ever increasing attempt by anybody who is responsible to exclude or limit the liability as well. So we'll have to keep all these in our mind. However, one thing for sure, that when negligence has been defined, it's been originally the reasonable man test, that is doing something what a reasonable man wouldn't have done in that situation, or not doing something which would a reasonable person had done in that situation. And who then is the reasonable person? The person who uses the omnibus on a daily basis from Clapham Common to whatever place it is. So that's an ordinary Londoner. And of course, ordinary Londoners do not design projects or do not build projects. So if we extend or borrow that concept and try to employ it for somebody who's a reasonably competent professional, he will always be able to say that, okay, I'm showing this design to somebody who was using the omnibus at Clapham Common, and if he can't find a problem there, then I have fulfilled my obligation. Well, I mean, this has been explained into the Bullem's test, which is now like universal, that when you are talking about a reasonable person, reasonable care and skill, in a scenario like this, we are considering today, we don't consider the standard of a person who doesn't know anything about this trade. So it actually, when we talk about doing something which a reasonable person wouldn't have done, it actually talks about a reasonable and a competent professional of the type which has been employed wouldn't have done. So that's one thing. And the second thing is, of course, the hidden agenda to duty to warn as well, because it's been kind of a core implied term, not necessarily always been implied on the employer's professional team, but I'm talking about across the board in the contract law, that if somebody comes to you, you're a professional, and then if they try to achieve something which is not possible or may not be possible, or want something which you think, for example, somebody wants a particular types of tiles to be used in some part of the building which is fire prone, and the tiles, you know, as an architect, or should have known as an architect, that shouldn't be used in that area. Now, if you say, what do I do? The employer asked me, that was the requirement. No, this is the case, Stormont Main Work and Men's Club. J. Roscoe Mill Partnership, 1988, reconfirmed that you've got a duty to ensure that the and exercise due care to ensure that the design should be reasonably effective to achieve. I don't know if that's disturbing you. Let me just put it somewhere else. Disturbing duty checks that you care to ensure that the design should be reasonably effective to achieve the client purpose. So clients probably is looking for a design which allows him or her to live in the place, or some human being to live in the place, and he of course doesn't want a dangerous building. So it's your duty, end of the day, to be able to point out that this is not going to work. So that's extra duty to warn, although not in the contract, will be there around you. Again, just to wrap up, I just had a slide to let us know if you are looking for the design liability. I'm a very kind of agricultural way to ascertain liability under a contract, which is nowadays, if I have a PDF version, I have a PDF software which allows me to search. Well, I'm mentioning this because at times I found colleagues have failed to find out. But if you have the PDF software which allows you to search, and which is a paid version, and tells you that this is a scanned document PDF, so I can't do the OCR. So would you mind if I take an OCR route, optical identification route, to find out the particular thing you are looking for? And if you say yes, then what will happen in the contract document? It will give a search. So you'll go through, but then never ever rely on that. That okay, I've typed into the contract document design. What does it say? What it is taking? Where is it taking me to? What are the information that has been incorporated into that? Let's say a traditional JCT contract, the recitals, the agreement, the articles, the particulars, and then the conditions, and then the secondary clauses. Through the particulars, some apply, some do not. And then that's what sometimes people just go through. No, that's dangerous. That's not only the express terms, because the contracts are frequently amended through the schedules. And the schedules, like contract sum analysis, contractual proposals, are very important to find out where the design responsibility lie. For example, traditionally it says the employer has examined the contractor's proposal for everything, meaning including the proposal for which the contractor has made a design proposal, CDP as we call it, or if it's a design build, then it's for the full thing. It's in the articles, oh no, it's in the recitals actually, that the employer has examined the contractor's proposal. First reference is there, and he's satisfied. Now, what is the result of this satisfaction? Will it exclude the design liability? Expressly, maybe so, but there will be an implied term, as I said. So remember to do a skimming exercise, create a tracker. I love Excel spreadsheets because I've become a quantity surveyor. But if you are not, you can create a table and type in the head note of design liability. And then if it's an NSA, the core clauses, the optional clauses, the works information, and things like that, and the schedules, and all these will come into place. And the design liability in JCT, do the same exercise. Well, if you do not have the access to the software I was talking, no harm, use your own reading and take help from another person, read jointly from the beginning till the end, see what are the clauses which are talking about the liability and the design and all this stuff, including the schedule. Try to understand whether it's been shifted or not, and what is the effect of a particular clause. And I hope that you'll get more confused than getting any clarity, and that's why people like us are there to tell you, you were talking about, remind me of the model, it's design and build JCT suit 2016. This is the nature of your responsibility, and you're the contractor, right? Yeah, this is the nature of responsibility. That's quickly done. But even if you're a professional like me, rather than thinking the JCT is my father's property and I'm the monarch of all that I survey, there is something called SRA or Bar Council, which might make you negligent for for providing your services. So it's better that you forget about your previous knowledge, like I prefer to. I might be an idiot, but I prefer to do so. That please, 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 give me some time, give me the contracts and the documents. I can give you a preliminary review like I'm doing there here with you, but I need to go to the specific wordings of the contract. And that I have, as I said, I've got Excel spreadsheet format of finding out and all the related clauses and the schedules, how the amendments stand and what is a case law. Law is no one's property. So, if you want to attach a particular meaning to a particular clause, there has to be an interpretation or a guide by the model form author. It's quite available. And at least if a decision is not there, a leading text, an author's explanation of what it means in the context you're checking. That goes to the express terms. But that much one non-legal professional can easily achieve, or a non-contract professional can easily achieve. However, then there are implied terms you got to keep in your mind. And don't forget the ever important tort of negligence, because there is a duty to take care and they can run parallelly. And when I talk about implied terms, I not only refer to implied terms of contract by common law, I refer to implied term by statutes. Now, one other thing I would ask you to keep in your mind, especially if you are drafting a contract, that's got a net contribution clause. This has gone to court of appeal in the context of a construction contract recently, back in 2014, in Finlay Associates. The architect's responsibility was to inspect mechanical and electrical fittings. If you're a contractor's professional, or a contractor, or an employer, builder developer of some sort, you know it for sure that the ordinary trick is the architect would always advise that, okay, even if I do the basic designs and the frames and everything, and employ structural engineers and others and oversee them, the electrical and mechanical should be thrown to the contractor. It's simply because they are not electrical or mechanical. Ordinarily, they're not electrical and mechanical professionals, and a large part of any building involves electrical and mechanical works, from the first fix to the decoration, up to the decoration point, and nowadays even electronically smart buildings, its involvement is more and more. And obviously an architect has never studied all these different disciplines, so it's sometimes difficult. And in modern sophisticated buildings, like there's lighting architects, there are sound architects, and so many other types. And increasingly in apartment buildings, or buildings of more than one level, the flooring and other things requires various types of sound compliance of standards of different types. So what they do, even in the simplest of buildings, they throw it to the others, and especially the contractor. You're an experienced contractor, take that responsibility. So what happens? The design responsibility is actually shared, because a brief or a preliminary design is prepared by the architect. Say, for instance, the locations of the lights and the switches and so on is prepared by the basic architect, and then thrown into the contractor to develop it into a workable model. Now, of course, in a normal scenario, unless excluded or shifted through express clause, both the architect and the contractor will be responsible for it. So whenever there are multiple parties who are responsible, there is a question of how to share if anything goes wrong. Because the basic common law position is, if the contract mentions or doesn't mention more than one party who are responsible, all of them are responsible equally and 100%, jointly and severally. So the person who's suing ultimately after the wrong has happened, he or she can just simply pick up the best one they believe is the party. So if they keep in their mind the solvency and easiest way to achieve the desired result. Now, and then the only option the person who has been held responsible for a wrong result for him or her is to countersue the other parties and say, look, you are responsible for this part of it. To avoid this multiple kind of litigation, it's possible to define in a contract a clause or add a clause in a contract which actually states how much contribution would you pay or make in a case if something goes wrong. That's called net contribution clause. So in this case, Western and Finley Associates, the architect is liable for failure to inspect mechanical and electrical fittings. So that was the breach. And the Court of Appeal held that the architect was entitled to rely on a net contribution clause in the conditions of engagement in limiting liability relative to the contractors. So in other words, if you are drafting a contract for a professional or even for a contractor in a model form, you add a net contribution clause, keeping in mind whether multiple parties are responsible, your liability will come down. So that's net contribution clause. It's kind of more of an advantage if you can insert it. And sometimes when the collateral warranty providers, they provide warranties, they sometimes want that clause to be included into the contract. So that's something you have to bear in your mind. This is one way of limiting it. The next, of course, the slide it follows, that's limiting the liability, because net contribution clause actually is an attempt to limit the liability. And what is limiting the liability? Limiting the liability as a concept in contract, and even it works in tort if you can draft it properly. And in the context of course, professionals, this has come in forth in the remarkable judgment of the House of Lords back in 90s, as it then was. Of course, it's no more House of Lords, it's UK Supreme Court. In 66, Hadley Byrne and Helen Partners Limited, that although you may be responsible for a negligent misstatement or negligence of tort, or even the same thing if it applies to contract, if you have successfully excluded your liability, and if it was reasonable for you to do so, you're not responsible at all, you know. However, that's an era or a zone where we had caveat emptor. I apologize that I've said something Latin, but that's, you know, when a judge cannot make any sense, you utter a Latin phrase, but in my case, it's different. I know the meaning. I will explain what that is. Meaning whoever is at the receiving end, he should be very careful, be aware that there might be, we don't live in an ideal world and there might be mistakes. So it's to the fullest extent the right of the person who's providing the service to exclude and discharge all the liabilities they have. That's the exclusion clause. However, it's been found that sometimes it's difficult, it's not reasonable to exclude. And of course, there's inroads of statutes like the Unfair Contract Terms Act. So it has to be kind of even if the limiting liability clause and exclusion clause is part of your contractual obligation of the other side, the side who is aggrieved, it may not stand if it doesn't pass the reasonableness test in a business contract. And in a consumer contract, you cannot even exclude certain liabilities. So if you do a wrong in a design process or in contracting process, and that results into a personal injury or a physical damage to property in a consumer contract where one party is a consumer, you will not be able to exclude those liabilities through an exclusion clause. However, in any possibilities of areas, there is a possibility to limit your liability, okay? And not completely excluding, but limit your liability. And it's easier in business contracts to do so. And now the point is how, this is just a practical example of Galliford Try and Mott MacDonald's. So the particular exclusion clause, which we are going to consider in this case by Mott MacDonald in their professional contract with the builder developer Galliford Try Infrastructure Limited. Sorry, this document had not been relied on or used in circumstances other than that, those for which it was originally prepared and for which Mott MacDonald Limited was commissioned. In other words, which Mott MacDonald is trying to say here is very simple. They were employed by the employer and they prepared their drawings and designs and everything for the employer. So if the contractor relies on it, so be it. If there is a mistake in it, or they were negligent, they're responsible to the employer, but not to the contractor. Just giving you a simple scenario, okay? So other than the person by whom it was commissioned, meaning the employer, Galliford Try, or maybe Galliford Try was the contractor, maybe they wanted to sue MacDonald for their negligence, and they rely on this particular design, and they say, look, hang on a minute, we have produced it, excluding our responsibility. You are not the contracting party, you cannot hold me responsible. And then if the employer is not willing, then MacDonald, what can they do? So what did the court say? The court said, so far as disclaimers are concerned, they're simply one factor, albeit possibly an important one in determining whether a duty of care arises. One cannot usually voluntarily undertake a responsibility when one tells all concerned that one is not accepting such responsibility. So the courts are willing to take this type of limiting clauses, and however, what they did cleverly force it as a question of fact type scenario, that whether even after this particular type clause, would the liability continue for the duty of care, at least more importantly in the context of the tort of negligence. It's a question of fact. All the facts and circumstances will be taken into consideration. Lord Denning said many years ago that insurance will be taken into consideration as well, that who was in the best position to take an insurance to cover such a liability. So these sort of things will be taken into consideration to come to the final conclusion. And of course, if we think that by discussing in a seminar we can achieve it, I'm sorry to say that's not possible. It's a complex question of law. So it's best that you, be it me or someone else, I may not be good enough, but there are hundreds of good lawyers around the city. So go and consult them before you make a decision. If you are a lawyer, don't just think I'm an adjudicator primarily, and I see lawyers coming in front of us who are very good lawyers, counsels and solicitors mostly, but they're not construction adjudication lawyers. And they essentially start arguing things which are not applicable to it. It's similar sort of things. It's a very specialized niche, and do not venture upon just by reading through or Googling it or this. Go to a specialized person in construction who does it on a daily basis. So How long shall I be responsible? The duration. Well, time and money, as we say in construction, we are kind of, it's inbuilt in our habit that we question this. Well, if it's a contractual one, we are talking about, or in other words, if the root of the responsibility comes under the express term or the implied term of the contract, and if it's a simple contract, meaning that it's not been signed as a deed, then the party in breach is responsible for 6 years till the date of signing, and 12 years if it's signed as a deed. And then if it's a breach, which has only become apparent to cause damages, then the period will, that's again Galliford Try and Asturia, most probably from the top of my head, but definitely Galliford Try was involved, from the date of the damage which has come forward. And 6 years in the case of total damages from the date it has been shown, so, or been seen, sorry, been seen. So that's the duration. Sorry, if you are, even if you have performed your obligation years ago, you may remain responsible for 12 years if the contract was signed as a deed. And of course, insurance shifts it, as we know that the contractors, they take NHBC or similar type of thing, insurance where for the first 3 years they remain responsible, and then the NHBC guarantees the rest of the period, and then perform that. Now, coming to the implied terms, because express terms and express terms, you have to read the contract, its schedules and all, to find out what exactly your amended contract is telling you. But implied terms are of two types, as I say, or three types, because it's similar to the tortious negligence: reasonable skill and care, fit for the purpose, and duty to warn. Reasonable skill and care I've already discussed at length, that it is the duty, and a similar one in the tortious negligence, duty to warn, which is extended to contract as well as an implied term occasionally, is pretty much along the line of what a reasonably competent contractor or a professional would have done in a situation like this. Now, I need to discuss a little bit more for the fit for the purpose aspect of it. Historically, unless expressly agreed, a professional is not that much liable in most cases for fit for the purpose thing. Exception, I have already discussed the Stormont case, that when you are preparing the brief, if you see something, if you're a reasonably competent one, that it's not fit for the purpose the employer is dreaming to, you come under responsibility. However, if it is a contractor's design portion or a design and build, where the contractor is liable to design, then he must ensure, that's the implied term, that it's fit for the purpose. And even though the contractor doesn't have any design responsibility, because when he's building as per the design, he is supplying various goods. And of course, the goods are specified by if the contractor doesn't have any design responsibility in the architect's document or specification document or whatnot. That the contract also says you've got to take into consideration all this time. Normally it says all the standards and rules of law and this and that. So if there is a non-compliant material, non-compliant, I mean that it doesn't comply a particular standard applicable in England or a statute, then you fall into the trap that it's not fit for the purpose. Also, regardless of, even if that's not the case, if it's not fit for the purpose, the goods we are talking about, and for example, somebody wants a cinema room and a sound system. I particularly had experience a couple of times of this sort, which makes it almost impossible for the size of the room and the building and all, to use it because it's too high, or it has kind of a noise effect too much within the building, or it's not been soundproofed such a way that other rooms and other parts of the building are having problem to use their part. So if you're a contractor, if you're supplying something like that, and if you can foresee or should have foreseen that this is going to happen, then you have an additional duty to statutorily implied that the thing you are doing is fit for the purpose. That's under 1982. So it's not only at the common law, and not only when you are responsible for design, if you're a contractor, you have this additional thing to keep in your mind. So just do not think, I don't know, mate. You asked me to do it and I did. No, that's not going to do. That's not going to do. You should take a serious note. And if you find any problem, you discharge, and you have performed it. If you raise it into a construction meeting to the design team and say, I want your clarification that you're happy with it. And if you have done that, then most likely than not, then there is a complaint, it will be said that no, he raised that issue, So final one, I think the JCT versus NEC. Well, JCT model has we got to think of two things. One is the JCT design and build. It was not there earlier, but due to ever increasing demand of the market, JCT has added this design and build, where more or less the practice scenario is the employer goes to an architect, they develop the design up to a level which is tendering stage level, and get the planning permission. So the basic design is there, and then the contractor is asked. There are various reasons for that. I'm not going to go there why that is there. The contractor is asked to make it into a workable design. There are loads of problems that starts because the architects then been novated for various purposes, so that the same person do the thing. But, and then please keep in your mind, I'll just touch that in a minute in the next slide, that the effect of novation. But what we need to keep in our mind that JCT has now in its design build clearly stated that the contractor is not responsible to verify the adequacy of the employer's requirement. Now, I tell you this, even though that's the case, you can get away with it in most cases, but the statutory obligation remains that you've got to supply and provide with goods which are fit for their purposes, and of quality and description and all these, suitable quality and description. All these are there. So that can kind of make you responsible partially from a design perspective. A similar rule applies for JCT, other contracts where the contractor is not responsible, but there is a CDP, contractor's design portion. So although it's not very clear what's the meaning of the clause that the design has been or the proposal has been accepted by and he's satisfied that the thing is fair enough and it's done properly, but it seems to have no effect when it comes to design responsibility. Okay, so still you have the duty. Now NEC, no clear-cut thing on your core clauses. Okay, it's in the optional clauses that defines. So if you are helping your client with NEC, please take extra care, because design responsibility is not dealt with in that fashion. Well, because it's engineering contract maybe, and not applicable for, or not meant to have been applicable or intended to have been applicable in building schemes, but nevertheless it's used widely in building schemes. So please do remember, check your optional clauses. There is provision there, but not in the core clauses. So you have to adopt them. Novation of design. Okay, that's another chapter. I actually have a full full presentation for it, so it's not the time and place to discuss it. But I will just simply say, like, what happens, the employer, this is normally a contract switch type scenario, the employer appoints the professional team, and then the design reaches a particular stage, the scheme is tendered, the contractor comes into place, it's design and build, and then the employer's team is novated to the contractor, the architect and the professional team becomes responsible to the contractor. Several possibilities may occur. The architect may retain its responsibility to the employer up to the date of novation. It could be novation ab initio, meaning the architect's then no more responsible to the employer. He becomes a contractor's designer from the day one, and the contractor takes on the responsibility of the design from the day one. So what actually happens in a particular novation is a matter for the novation agreement, and it's pretty much specific to that. And as I said, we have a different presentation for it. You'll find the recorded version on the internet already, and you may attend when we do it next time. And with that, I believe I'm done, concluded. Any questions from your side?
Okay, haven't had any questions submitted during that presentation, so I can assume that you have answered everyone's queries fully. If you do have a question, now is the time to put that to Mo in either the Q&A or chat panel, or as we've said previously, you can email him directly, mohammed.haque@fletcherday.co.uk. In the meantime, we are back this evening with John Sharp in an update to his COVID and the insurer's response. And then tomorrow we are with both John and Mohammed on the construction roundup, where they'll be talking about things they've been looking at in construction over the last couple of months, updates, new cases, etc. So if you'd like to book a place on either of those, please don't hesitate to email me on seminars@fletcherday.co.uk. Otherwise, everyone have a great day. Mohammed, thank you very much for your time. Thanks everyone for attending this morning, and we will see you all again soon. Take care, everybody.
The audience as well for keenly listening.
Indeed. Thank you.
Cheers. Take care. Bye-bye.
Bye-bye.
Right. So tomorrow